Navigating USCIS audits, employer consequences and next steps. If an employer or consultancy gets caught violating USCIS regulations during an audit or investigation, the consequences can range from administrative penalties to criminal charges, depending on the severity and nature of the violations. Here's what could happen. Revocation of approved petitions. USCIS may revoke previously approved petitions, H-1B, L-1, etc., leading to employees losing their legal work status. Employees might need to leave the U.S. or find another employer to transfer their visa. Civil penalties. Employers may face fines for non-compliance, such as failing to pay the prevailing wage or not adhering to Labor Condition Application, LCA terms. The Department of Labor, DOL, may impose penalties ranging from thousands to millions of dollars, depending on the scale of violations. Debarment from immigration programs. The employer could be prohibited from participating in immigration programs, for example, filing H-1B, PERM, or green card petitions for a specified period or permanently. Worksite closure or suspension. In extreme cases, the consultancy may be forced to cease operations temporarily or permanently if found engaging in fraudulent activities. Criminal prosecution. If fraud or willful misrepresentation is involved, the employer could face criminal charges. Penalties may include imprisonment for company officials or executives and hefty fines. Public blacklisting. The employer may be publicly listed as a non-compliant or debarred entity by USCIS or DOL, damaging their reputation and ability to attract business or clients. Loss of work status. Employees on visas sponsored by the employer may lose their legal status in the U.S. if the petitions are revoked. They might have to leave the U.S. immediately unless they can transfer their visa to a compliant employer. Delayed green card processing. Employees in the green card process may face significant delays or denials if the employer is found non-compliant. Future immigration issues. Employees may face scrutiny in future visa or green card applications due to their association with a non-compliant employer. Immediate legal representation. Engage an experienced immigration attorney to handle the case, respond to USCIS, and manage any penalties. Cooperate with authorities. Cooperate fully with USCIS, DOL, or other investigating agencies to mitigate penalties. Rectify violations. Take corrective actions such as paying back wages, updating employment policies, and ensuring compliance moving forward. Appeal or request review. Employers can file an appeal or request administrative review if they believe the findings were incorrect or penalties were too harsh. Implement compliance programs. Develop robust compliance systems to prevent future violations, including conducting regular internal audits and staff training. Seek new sponsorship. Transfer the visa to a new employer as quickly as possible to maintain lawful status in the U.S. Consult an immigration attorney. Get legal advice to understand options and avoid falling out of status. File a whistleblower complaint if applicable. If the employer engaged in fraud, employees can file a complaint with the DOL or USCIS. Whistleblowers may sometimes receive protection under U.S. laws. Always comply with immigration laws, including wage and job requirements. Maintain transparency with employees and clients. Regularly review and update internal compliance practices. Consult with legal experts for all immigration filings. For more answers to your queries, please visit www.adaklc.com.